Question 496. After a trustee's sale in a non-judicial foreclosure, any proceeds left over after paying off liens and foreclosure expenses belong to the A. Sheriff, B. Trustee, C. Foreclosed upon owner, D. Beneficiary. Correct answer is C. Foreclosed upon owner. In a non-judicial foreclosure, also known as a trustee's sale, the proceeds from the sale are distributed in a specific order. 1. Foreclosure expenses. Costs associated with the foreclosure process itself, trustees' fees, advertising, etc., are paid first. 2. Senior liens. Any liens that have priority over the foreclosing lien, typically the first trust deed, are paid off next. 3. Foreclosing lien. The debt owed to the beneficiary who initiated the foreclosure, usually the second trust deed holder in this scenario if a first was already in place, is then paid. 4. Junior liens. Any remaining proceeds are used to pay off other liens against the property in their order of priority. 5. After all valid liens and foreclosure expenses have been satisfied, any surplus funds remaining belong to the former owner of the property, the foreclosed upon owner. Therefore, the law ensures that the foreclosed upon owner receives any excess funds after all legitimate claims against the property have been satisfied through the trustee's sale. Question 497. A non-physical incursion into another person's property would best be described as A nuisance, B. Encroachment, C. Eviction, D. Avulsion. Correct answer is A. Nuisance. An encroachment is a physical intrusion onto another person's property. Examples include a fence built over the property line or a building overhang. The question specifically states, non-physical. Eviction is a legal process by which a landlord removes a tenant from a property. It relates to possession, not a non-physical incursion from a neighboring property. Avulsion is a sudden and perceptible change in the boundary of land caused by a sudden, forceful action of water, like a river changing course. This is a physical change in the land itself, not a non-physical incursion. A nuisance is a condition that interferes with another person's use and enjoyment of their property. The key is that it negatively impacts the owner's ability to comfortably use their land. Question 498. The term used when an amendment is made to a will is A. Rider, B. Codicil, C. Devise, D. Probate. Correct answer is B. Codicil. A rider is often used in contracts, not wills. It refers to an addition to a contract that modifies its terms. A devise is a specific gift of real property stated in a will. Probate is the legal process of administering a deceased person's estate, which includes validating the will and distributing assets. It's not the term for amending a will. A codicil is a legal document that formally amends an existing will. It allows the testator, person who wrote the will, to make changes without having to rewrite the entire will. Question 499. Which of the following would likely not be a good defense by a tenant against an eviction? A. The landlord's notice of eviction seeks more rent than is actually due. B. The premises are infested by termites. Correct answer is C. The tenant just lost his job. In order to evict a tenant, a landlord files an unlawful detainer lawsuit in court. Good defenses to the eviction include the landlord asking for more rent than specified in the lease terms. The property is in violation the warranty of habitability, termites. While a job loss is a difficult personal circumstance, it generally does not constitute a legal defense against an eviction for non-payment of rent. The tenant's inability to pay due to job loss does not negate their obligation under the lease agreement. If the court decides in favor of the tenant will not have to move, and the landlord may be ordered to pay the tenant's legal fees. Question 500. When title to a property is given to the lender as a guarantee against loan repayment, but the borrower maintains possession of the property, it is called A. Hypothecation, B. Collateral, C. Reconveyance, D. Qualified endorsement. Correct answer is A. Hypothecation. Collateral is a general term for any asset used to secure a loan. It doesn't specify whether the borrower keeps possession or not. Reconveyance refers to the transfer of title back to the borrower after a loan is paid in full. It's the opposite of what happens in hypothecation. Qualified endorsement is a term used in negotiable instruments, like checks, where the endorser limits their liability. It's not relevant to property ownership. Hypothecation describes a situation where a borrower pledges an asset, like real estate, as security for a loan, but retains ownership and possession of the asset. The lender gains a secured interest in the property, and if the borrower defaults, the lender can foreclose to recover the loan amount by selling the property. The lender gains a secured interest in the property, and if the borrower defaults, the lender can foreclose to recover the loan amount by selling the property. Question 501. A bank loan officer was referred a client by a real estate agent. Then, the loan officer sent the agent $100 in cash as a present. The agent should return the money because it is unlawful to accept it, under the provisions of A. RESPA, B. The Rumford Act, C. Regulation ZD. The agent can accept the money, there's no law against expressing friendship. Correct answer is A. RESPA. The Rumford Fair Housing Act, in California, prohibits discrimination in the sale or rental of housing based on race, color, religion, sex, marital status, national origin, ancestry, familial status, disability, or source of income. It doesn't directly address kickbacks or referral fees in lending. Regulation Z implements the Truth in Lending Act, TILA, and focuses on requiring lenders to disclose the terms and costs of credit to consumers. While it aims for transparency in lending, it doesn't specifically prohibit referral fees or kickbacks between settlement service providers. RESPA prohibits kickbacks and unearned fees in federally related mortgage loan transactions. The $100 cash, present, from the loan officer to the real estate agent for the referral is considered an illegal kickback. RESPA aims to prevent hidden fees and ensure consumers have transparent and fair settlement processes. Accepting such a payment creates a conflict of interest and can lead to steering consumers towards certain service providers based on personal gain rather than the best interests of the client. While expressing friendship is generally acceptable, the context of a referral in a real estate transaction involving a federally related mortgage loan makes this present fall under the prohibited kickback provisions of RESPA. The law recognizes that such payments can influence professional recommendations and harm consumers. Question 502. After filing for Chapter 11 bankruptcy protection, a corporation's board of directors had no plan for handling the firm's reorganization. How long from this point in time until creditors can present their own plan? A. 1 month, B. 90 days, C. 120 days, D. Immediately, since management's failure to fashion their own reorganization plan gives creditors the right to present theirs right away. Correct answer is C. 120 days. Under Chapter 11 of the U.S. Bankruptcy Code, the debtor, in this case, the corporation, has an initial exclusive period during which only they can file a plan of reorganization. This exclusivity period is typically 120 days from the date of the bankruptcy filing. If a debtor doesn't file a reorganization plan within 120 days, or if creditors don't accept it within the following 60 days, the debtor loses their exclusive right to propose a plan. After this 180-day exclusivity period, creditors can then submit their own reorganization plans for the debtor's business. Since the corporation's board of directors has no plan at this point, the creditors must wait out the initial 120-day exclusivity period before they can file their own plan. The court can lengthen this period at management's request, but will eventually pass control of the firm's affairs over to creditors. Question 503. The types of remedies for breach of contract. A. Specific performance. B. Damages. C. Lee pendens. D. Either A or B. Correct answer is D. Either A or B. Lee pendens is a notice filed in the public records to warn potential buyers or lenders that there is a lawsuit pending that could affect the title to the property. It's a notice of a legal action, not a remedy for breach of contract itself. Specific performance is an equitable remedy where a court orders the breaching party to fulfill the terms of the contract. It's typically used when monetary damages are inadequate, such as in real estate contracts where the property is unique. Damages is a legal remedy where the non-breaching party is awarded monetary compensation to cover the losses they incurred due to the breach. There are various types of damages, such as compensatory, consequential, and sometimes punitive. Question 504. Prima facie means. A. First in priority. B. Primary evidence. C. Main balance. D. Principal. Correct answer is B. Primary evidence. Prima facie is a Latin term that literally means, at first sight, or, on its face. In legal contexts, it refers to evidence that is sufficient to establish a fact or raise a presumption. Essentially, it suggests something is considered true unless proven otherwise. It's considered primary evidence because it's the initial evidence presented that, if not challenged, would prove a particular claim. Question 505. If a deposit receipt states that a property is sold, as is, then A. Seller has no obligation to disclose material defects to the buyer. B. Seller still has an obligation to disclose material defects to the buyer. C. Clause does not apply if defects are not immediately apparent. D. As-is clauses are illegal in California. Correct answer is B. Seller still has an obligation to disclose material defects to the buyer. In California, and most other jurisdictions, an as-is clause in a deposit receipt or purchase agreement does not relieve the seller of the duty to disclose known material defects to the buyer. Sellers have a legal obligation to disclose any facts materially affecting the value or desirability of the property that are not known to, or readily observable by, the buyer. This duty arises from the common law and statutory requirements. An as-is clause generally means the buyer accepts the property in its current condition, including any visible defects. It protects the seller from liability for patent defects, those that are obvious upon reasonable inspection. However, it does not shield the seller from liability for latent defects, those that are hidden and not easily discoverable, that the seller knows about but fails to disclose.